Go ahead and call the meeting to order. Roll call, please.
Brian Crawford,
Present.
Monte Matalago,
Present.
Vernell Neville,
Present.
Sarah Pari.
Correct.
Phyllis Simeon,
Present.
Jared Ricky,
Present.
Lenore Feeney.
Here.
Jason Hanneman.
Here.
And Erica Dorsey.
Moment of silence, please.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice.
We only have one request. We have one request from Robert Burns to speak on two different items on the agenda. Mr. Burns, first will recognize you to speak on item number 4 under the business items. Sir, we know who you are, but
I'll introduce.
introduce yourself.
Yes, there was a time when you didn't. That was a long time ago, wasn't it? I
Long
am-
time ago and many articles ago.
Well, that's true. I am Robert Burns with video blog Sound Off Louisiana. And I appreciate the opportunity to address each of you today because I know at the last meeting, there was discussion about recruitment problems and some talk about pay scale changes or whatnot to try and alleviate those. I feel compelled to speak out in 6.5 years of having closely monitored state police, and as you've said, published many articles in that regard. And I think it's a recruiting problem when a trooper who reports wrongdoing and gets told that quote, you need to chop wood and carry water. I think it's a recruiting problem when another trooper who is actively involved in that same investigation states on camera before a committee meeting that, quote, I won't cheat, lie, and I won't participate in a cover-up. I think it's another recruiting problem when you have cadet examinations administered in which flash drives with answers are disseminated widely and destroy the credibility of those who would subsequently wear those uniforms, and nothing substantive is done about it. I think that's a serious recruiting problem. And I know that the simple solution may be, well, let's just throw more money at it. That tends to be the knee-jerk reaction. And I would submit to you that if just throwing more money at it would solve the problem, I wouldn't have video of an existing trooper named Scott Lopez who stated on video, and I quote, well, they're making $80 an hour and they're leaving in droves because that's how bad it is, unquote. So I will certainly be respectful of the arguments that are opposed here today about anything to do with trooper compensation. But as far as recruiting, I think there are far more substantive reasons as to why LSP has a recruiting problem. Because when you see things of the nature that I have just enumerated, I think that anyone potentially considering entering the LSP profession, it's not like all of this is happening in little closed meetings. This is all stuff that's been pretty well disseminated. And I think a prospective recruit is likely to say, you know what? And I haven't even mentioned all of the promotions that have taken place by troopers who were known to have engaged in serious wrongdoing. And so I think one who may have a good name and would otherwise certainly be a fine recruit to serve for Louisiana State Police and ultimately be a trooper is quite likely to reflect and to say, you know what? I have a good name. I'm going to protect it. So I'm just going to tell you that I believe that money-related issues don't get to the root core problem that exist at state police. And with that, I thank you for the opportunity to address you this morning.
Thank you for your comment. You also requested to speak.
Well, it was combined.
Oh, you just.
Yeah, it's combined.
Thank you, sir. Okay, we'll move to the business items on the agenda. Consideration of the minutes from February 9 of 2023. We have any motions?
So move.
Move to accept and second it. All in favor?
Aye.
Any opposed? The ayes have it. Second item on the agenda, oral arguments on the pre-hearing motion filed in the matter of Michael Richard Reichardt, Department of Public Safety and Corrections, Office of State Police, docket number 22265S. Devin T. Jones representing Mr. Reichardt and Jason Hessick representing the Office of State Police. First thing I want you to do is tell me the proper pronunciation of the trooper's name, and I apologize, I slaughtered it up here.
Reichardt.
Reichardt.
Yeah, you got it. Got it right the second time.
With a name like Eula Simeon, you would think I could pronounce everybody's name, but I'm the worst name pronouncer that you know. So. This is your motion, sir. You can proceed. After you identify yourself, please proceed.
Devin Jones on behalf of Mr. Trooper Reichardt. Commissioners, today before you is the motion for summary disposition by Trooper Reichardt in this matter. We filed an initial motion for summary disposition back in, I believe, September, October. We supplemented that motion with an amended motion for summary disposition, which incorporated exhibits with it. Those exhibits were specifically exhibits from the retired Colonel Kevin Reeves, retired Chief of Staff Robert Brown. I would point to you that the undisputed facts that are established in those affidavits and established in the other exhibits which are attached to the news report from January of 2022, and along with looking at the 720-hour suspension letter, the one that was the first initial one, and then the final suspension letter, establishes that the conduct that encompasses the incident in this matter, which is what we're looking at underneath Rule 12.18. When did the incident occur? When did they know of the incident or learned of the incident is the operative language. Colonel Reeves establishes in his affidavit that he learned of the incident on May the 21st, 2021 or 2020. He learned of an incident where Trooper Reichardt's prescription drug records had popped up in what was a joint LSP-DEA investigation. He had been receiving what were opiates from a Dr. Scott Burkett, who was under investigation. On that date, he learned of it from, at that time, Major of Investigation Robert Brown. Robert Brown puts in his affidavit that he contacted Colonel Reeves, informed him of it because they wanted to pull the P&P records of Trooper Reichardt. He needed the colonel's authority to do that. He meets with them at LSP, at his compound, at his residence on the compound on the LSP grounds, meets with him, meets with Lieutenant Colonel White and the other Lieutenant Colonel. On that date, they had a meeting. He articulated to him the Trooper Reichardt's records, prescription opiate records, were showing that he received these prescriptions from Dr. Burkett, who was a cardiologist, and it was not known that Trooper Reichardt had any cardiology problems at this time. It was known that he had a work-related workers' comp case related to his knees. The conclusion of that meeting, Colonel Reeves gives his authority, and you can read it in his affidavit as we've cited in our amended motion for summary disposition, that he gives them the authority to pull his P&P records, his prescription records, to see where he's receiving prescriptions from. On June 1st, if you look at the 720-hour letter, it dictates that on June 1st, Trooper Reichardt was questioned by Trooper Baker in regards to receiving those prescriptions from Dr. Scott Burkett. He gives his statement. His statement is that he consistently has said in that statement and subsequent stating in the internal affairs statement that he gave that he was receiving these medicines because his knee was hurting. Dr. Burkett was a friend of his, was actually a close neighbor. He received them for a short period of time, 6 months, in the quantities that they established through his PMP records. On June 3rd, 2 days later, then Major Investigations, Robert Brown, goes to Metro Narcotics in Monroe, which is a joint task force, meets with Trooper Baker and a DEA agent. They at that time disclosed to Major Brown that Trooper Reichardt is not a suspect, not a subject of the investigation, nor is he a target. He would simply be a witness. Major Brown then goes back to Baton Rouge to the barracks or the compound, the colonel's residence, confers with both lieutenant colonels and the colonel, and they all together confer what has been relayed to him in the investigation, that he's not a target, he's not a subject, he was simply a witness, what they learned through the statement, and conveys that to Alden. And from that point forward, until Colonel Reeves leaves in October 31st, nothing is done. When Major Brown, who then ascends in the summer months to being chief of staff, Brown, nothing is done by the state police to initiate an investigation. 12.18 states that they have to have, when they have knowledge but no formal complaint, they have 14 calendar days from the date they learned of the incident. They learned of the incident initially in May. Moreover, we know that after his statement on June 1st, they learned of it on June 3rd per their affidavits, which would be their testimony. Those facts are undisputed. And still nothing occurred. What further cements that no investigation occurred is if you look at the exhibit from the report from the media in January of 2022, the now Colonel Davis states to the news media that this was an incident that occurred in a prior administration, which he feels was not investigated. Next day, he initiates an investigation. The date calculation from the date they knew in May to the date that it starts is 600 days. 12.18 allows 14 days for this to occur. We're in excess of almost 586 days. This trooper has never been indicted. This trooper has never been called to court to testify about his witness stuff for 586 days until the now colonel gets asked by a TV reporter about what happened in a previous administration. Now they started. And the end result was he received a 720-hour suspension for something that hadn't been investigated for 600 days. These troopers have rights. Those rights are incorporated in Rule 12.18, which says you must initiate an investigation within 14 days learned of the incident. I've read the opposition to the summary dismissal by the Department of Public Safety. Their opposition simply states, we need for this commission to define to us what learns of incident is. As a law practitioner, laws are given their ordinary meaning. That's a cardinal of statutory interpretation. Their plain meaning. The plain meaning of learns of incident is the date they knew. And in 12.18, the date that the appointing authority, the colonel, knew was May, and then we know for sure in June 3rd, 2020, he learned of everything that existed in this file. If you read the 720-hour suspension letters, the statement that was given by Trooper Reichardt on June 1st mirrors the statement that was given to Internal Affairs again. There is no new development of information. This is the same incident that occurred almost 600 days prior to the initiation of the investigation. We've asked for summary disposition based on those undisputed facts that are established in those affidavits. When you ask for summary disposition, it states in there that you can attach exhibits to establish these things. I will point out to the commissioners that in their opposition to the motion for summary disposition of appeal, they have attached no evidence to controvert those. That is uncontroverted evidence at this point. Undisputed, which clearly establishes that the rule was violated, that he is entitled to dismissal of this, as is outside the time limits. I will also note,
Do you dispute the fact that this commission has in the past indicated that the violation of that rule is a factor that we will consider at the hearing in assessing the reasonableness of the discipline and the propriety of discipline at all? But it doesn't necessarily deprive us the opportunity to review the facts of the case to examine the discipline.
I do submit to this commission, I do admit that the rule does not provide for what occurs if that happens. And this commission has plenary authority.
Question. Are you aware of this commission's prior rulings that a violation of that rule does not necessarily result in a dismissal of the discipline? And it is a factor that this commission will consider in evaluating the propriety of discipline or the extent of discipline.
Yes, I am. I am aware of
Have
that.
anything to address to that?
Anything to address to the,
That prior ruling, those prior rulings of this commission? I don't think we're gonna have a big dispute about what the facts are. I'll ask that of the state troopers, but I want to address that issue.
to that issue, I think it goes to the reasonableness of the penalty. This is 2 years later. This is greater than 2 years later. This penalty has been enacted. This is the most hours that can be taken from a trooper for an incident that has not been criminal. He was not a subject. He was not a target. It was simply an incident where you have this trooper receiving pain medication from a doctor.
But if we get into the question of the reasonableness of the discipline, don't we have to have evidence that relates to that question? Reasonableness, one of the factors being the delay, but are there other factors that might be involved in evaluating the question of reasonableness?
There are other factors that go into the reasonableness. It's a multitude of factors, and I do submit that. The only other thing I would point out that I did point out in our privately is that the opposition is a non-conforming opposition due to the certificate on it. It fails to properly give, as the rules require, the notice aspect. And that's all I ask. It's just a procedural argument on that.
Tell me what you mean by that.
The rule 13.5B1 requires that the certificate that is attached to any opposition or any response to a document requires that it's certified that notice was given in the same manner in which it was submitted to the other parties, and the person undersigning it does. In this case, the certificate states that served a copy of the above foregoing on Matthew Clare through his counsel Floyd Falcon by placing a copy in the same United States first class mail, postage prepaid on the 6th day of March 2023.
That's a scrivener's error. Apologize.
And that's it. I pointed out for procedural reasons.
Anything else?
That is it, commissioners. Thank you.
Yes, sir. Make your appearance and.
Uh,
Well, let me ask, go ahead and make your appearance first, and then I got a question after you do that.
Good morning, Commission. Jason Hessick on behalf of Office of Legal Affairs, Department of Public Safety and Corrections.
Good morning. I was not here when you introduced yourself last time. I was late for the last meeting. Nice to meet you, sir.
Nice to meet you as well. And Commissioner Neville, I don't know if we've had an opportunity to meet or chat, but it's also nice to meet you as well.
Nice meeting you as well.
So do you dispute any of the facts relative to the time?
Yeah.
Okay, let us hear about the facts and what evidence you have to support that dispute.
Yes, sir. I'm going to first turn to the motion by Mr. Jones in this matter. I appreciate his arguments. However, argument from an attorney is not fact. Based off of the affidavits and the information that is contained in here, we know these facts. That Louisiana State Police was advised that Trooper Reichardt had gotten prescriptions from Dr. Scott Burkett, a cardiologist, for opiates. Fact number one. That Colonel Kevin Reeves was advised of this, that one of his troopers was receiving opiates, which is not a crime. A prescription for opiates is not a crime.
He was advised of one of his troopers, or was he advised that this troop?
This trooper.
Okay.
And that at
Did you
the,
not say that that's knowledge?
well, I'm getting to that. I'm getting to that.
Let's get to it now. Is that not knowledge?
So do not know specifically what was said to Colonel Reeves in that, other than one of his troopers had gotten prescriptions
This
for
trooper,
opiates.
okay.
This troop, correct. This trooper got prescription for opiates. There was no indication at that point that anything in that arrangement was illegal or that it deserved looking into. May 21st, 2020, they have a meeting on it. The affidavits do not specify exactly what was said in detail in those meetings, but we do know at the conclusion of that meeting, Colonel Reeves granted Major Brown the authority to gain Trooper Reichardt's PMP records. And just for clarification, PMP records are prescription records. It's the same in the motion. It is same in the affidavit from Colonel Reeves. It is same in the affidavit of Mr. Brown, that he ordered PMP records. Nowhere in those affidavits does it state that they ever received those PMP records, and anybody ever followed through with that order, that they ever reviewed those PMP records. We turn to May 26, 2020, and I'm nitpicking here, but I think it deserves clarification on these points. May 26, 2020, Major Brown met with Metro Narcotics in West Monroe. The only thing that we can take from that meeting, from the affidavits, from the motion, is that he was informed by both that Trooper Reichardt, he was informed that Trooper Reichardt was not a subject or target of an investigation and would be used as a witness. The use of troopers in investigations is something that happens almost daily. That is not something that we can rely upon.
There an indication that the records have been obtained?
At that point,
The PMP record.
no. There's no indication in the motion and the affidavits that they ever got PMP records. They had a meeting after that on, it looks like 2 meetings, May and June, where no further action was taken by Louisiana State Police. And the only information that seems in detail to pull out of that was that Colonel Reeves was advised that Trooper Reichardt was not the subject of the investigation. He was a witness to that. Again, something troopers do every day. Past that, we have to look at June 1st. June 1st, Trooper Reichardt met with CID. During his interview with CID, and by the way, this is past the deadline that they are telling us set by the 14 days. On June 1st, 2020,
Run that by me again. I'm sorry.
as in they're saying,
Everybody else probably got it, but you lost me.
right, I apologize. They're claiming that the timer should have started for Trooper Reichardt for his 14 days in May. I'm just pointing that out, that was their argument.
If it started in June, or July, or August, or October, anytime more than 14 days before it actually started.
You were absolutely
let's
right.
Let's not go there, okay?
Okay, well, I want to go there to make points here. June
Hey,
1st,
if you want to go there, but I'm telling you, it's not going to be a significant argument in my mind unless it's less than 14 days. But you go wherever you want to go.
understood. Thank you, sir. On June 1st, 2020, Trooper Reichardt advised CID that during the course of 6 months, he had received approximately prescriptions for approximately 470 Percocets and a prescription for 44 tramadol per month. That comes from 2 different doctors.
So apparently, They must have had the PMP records, right? I also wouldn't have known that information.
It does not indicate that they had those records, that was his testimony at that, or that was his interview at that time.
All right.
What is significant about these numbers, and that 470 over the course of 6 months, great. What is significant about that is over the course of 73 days, he told them that he received prescriptions and filled prescriptions for 270 Percocets. To frame that, I had surgery in December on my shoulder.
What happened to you and your surgery? I don't want to hear.
All right, very good. Thank you, sir. The CID investigation, there's no indication that that information ever made it to Colonel Reeves, ever made it to Mr. Brown in any of their affidavits and any of the documentation provided by counsel. The first time that we see it in our records is in the investigation involving one of the doctors in September. There's no indication that information made it up the chain. I'm pointing this out to give that timeline about why we don't think the timer should have started back then, about why that timer should have started in 2022. My takeaway from this information, knowing that Colonel Reeves was the head of one of the biggest agencies in the state of Louisiana, that he is a rational man, and that if he was told at any point that his trooper received over the course of a 73-day period 270 Percocets, I believe a rational man would have asked somebody to look into that, including IA, to start investigating that. I don't know anything about Colonel Reeves. That's not my place to talk about anything dealing with him. I do know the current administration over at Louisiana State Police. I do know right now they are trying day by day to turn that organization into an elite task force that the people of Louisiana can be proud of and other states can look to for guidance. Now, they're doing some remarkable things with the cadets right now, emotional intelligence training so that they work through their emotions before making decisions in the field. They've worked on programs to get help to troopers that need it. I believe that if they knew about this back in the day, and it was this administration, number one, if they were told by a supervisor, we got a person here that has 270 Percocets over the course of 73 days.
You can't evaluate what the previous administration knew based on what you understand the current administration would do.
Understood, sir.
So
Understood.
let's stick to the facts that are pertinent to whether or not the previous administration had knowledge that should have started. the clock.
Yes, sir. So getting to the point of this, part of that process of making an elite organization is that, and I hate to say it, I know that they don't like it. I know that the commission doesn't like it, but it requires disciplinary measures in some instances. The system that they wish to set up based on.
There's no problem with requiring disciplinary measures in some instances. I go on record, I think I can speak for everybody else when I say that. That does not offend us by any stretch of the
Very good.
imagination. I think we've made that clear in the past, so please do not make that implication about us.
Yes, sir. But what counsel over here wishes to for his client is that we use a very liberal interpretation, number one, of what learned of the incident means. And number two, that the 14 days period is an absolute prescriptive period that nullifies the disciplinary measures. As to that first point, their liberal interpretation of that, any type of breadcrumb, any type of modicum of information, an officer knocking on the door or putting his hand on the door of his superior officer saying, hey, something happened tonight, I'll let you know about it down the road, going to do some reports, yada, yada. They want that to be the start of the 14-day period to run regardless of the information that is in the hands of the commanding officer that they just spoke to. Quite frankly, if we took that interpretation, I believe that we wouldn't have disciplinary measures, because for almost every trooper out there, there would be a way for them to put in 14 days for the calculation.
Purpose of the investigation.
What's that?
What is the purpose of the investigation?
You mean the IA investigation?
To begin the investigation that leads to this one, what is the purpose of that investigation?
Do you mean for the investigation, not the IA investigation?
I mean, the investigation that leads to the discipline, what's the purpose of it? Is it not to not only to get the details, to get more specifics, to understand specifically what is alleged to have happened, as opposed to you can turn a blind eye until after you do the investigation before you can argue that you have knowledge? Is that's not the
Oh,
purpose? of
no,
the
absolutely. No.
So don't you think that there was sort of a blind eye in this case?
You mean as to when the start of the investigation?
Follow
can-
your argument on when the knowledge occurs. My view would require us to say that you can turn a blind eye to the information that you have. And until later on, you get some more information, which won't happen until after you begin the investigation. It has to start within 14 days of having some knowledge. Where would you draw the line? I
You
mean,
know-
how much do they have to know?
I'm glad you brought that up, Commissioner. And I think we might be on the same page here of where I'm getting. I absolutely understand that going the opposite direction leads us to that situation where we close up our file, we don't look at it, and then we just pretend like we haven't started an investigation. We haven't looked into it. Oh, now the 14 days starts. I understand. I don't believe that Louisiana State Police has any intention of doing that. I don't believe that they want that for their troopers. And here is my proposal to you. I believe that the 14 days that we're talking about is a matter of interpretation for the commission. And this is a problem that happens in every agency, Division of Administration, Public Service Commission, everything that relies on administrative laws and codes. We have an appetite for Code of Civil Procedure that covers every single base, but we're doing it on administrative code, on what we can get done. And that's because this commission can't come up with code for every single thing that can appear before this. That would be ridiculous. So that leads to the commission, as finders of fact, to interpret their own laws, the rules that they came up with, to come up with a solution for these matters. My proposal, and I was going on a little bit there. My proposal is that we get these officers in here to get testimony from them, for the commission to look into exactly when the 14 days started and its effects on this investigation. And my proposal to you about how to judge that, and you as a law professor, I'm sure that you've taught this at some point. It's an objectively reasonable standard based on knowledge or constructive knowledge that the troop should have or their commanding officer should have in these moments. And that's a determination for the commission to come up with.
If I had instructed, if I had taught that in my class, next thing I'd have to tell them is that you could never have a summary disposition. Is that what you're telling us?
Well, you can have a summary disposition where,
On this issue,
on this issue,
that what you're telling us?
I think if there was undisputed fact and law in this matter, I think you could have a summary disposition. I don't think it's going to be one of those things that is going to happen that often, if at all. Quite frankly, that's because of the wording of that statute about, or that rule about learn of the incident, which I leave up to the commission to interpret.
What about the other basis of your argument? At least I heard you say there were two, one.
Well, the other one,
knowledge and the other being it's not an absolute bar.
thank you, Commissioner, for reminding me. As I said before, it is a very short, we can't go into detail about exactly what happens in every instance. As you stated before to council, there's no rule in there that says that this is a prescriptive period or a bar to the discipline or the litigation in this matter. That is kind of the area that I was going with my second argument there, in that there's nothing there that says that. And I think that, again, is left up
Actually, there's
to,
been rulings that say the contrary.
oh, really?
There's been rulings by this commission that say just the contrary, that it's.
And that was,
to the argument that it's an absolute bar.
okay. Well, thank you for that, sir. I think that goes with what we're saying, that this commission needs to be the ones to interpret how that 14 days prejudices both Trooper Reichardt, prejudices the Louisiana State Police and being able to enact discipline when they need to, and needs to weigh the public safety of the citizens of Louisiana and the ability to discipline and make sure that they're safe. I'm leaving that up to the commission, is what I'm saying, to make that determination. That is the conclusion of my argument. I welcome Mr. Jones as a rebuttal. I welcome any questions from
You're
the
trying to take
commission.
my job away. from
Oh,
me.
no, I apologize. No, I'm not trying to do that.
Okay.
And I know I'm completing my argument, and Chairman Simeon, I
Was only joking.
oh, no. Chairman Simeon, as an attorney, I welcome argument and banner, sir.
He's already given you the right to a rebuttal, so go ahead.
I'll wait for the chairman to recognize it. Been before the legislature a few times. You don't make that mess up but once. I have
Make it brief, please.
I have one quick point. If you will look at the intended 720-hour suspension on page 2, which would be the third paragraph, it's also included in the 728-hour final letter. It actually tells you that they detail in there what occurred in the investigation on June 1st, 2020, and it states they had the PMP report at that time.
Where does it say that?
That is on the third paragraph of the intended 720-hour suspension, would be page 2, starting with the first full sentence on line 1, starting halfway through. It states they had the PMP report when they questioned him on paper.
Who had the PMP?
Louisiana State Police had the PMP report when they questioned him on June 1st regarding the quantities and types of prescriptions that he had.
Does it indicate whether that information had been related to man?
Yeah, retired Chief of Staff Brown relayed that he met with them afterwards and was informed of all the aspects of it. And that's when he relayed it back to that. That's my short rebuttal. Thank you.
All right, thank you. The matter has been argued. Entertain a motion, if there is one, relative to executive session to discuss the issues related to alleged misconduct.
I'll move.
Second. We have a motion and a second. Take a roll call, please.
Brian Crawford,
Yes.
Monty Matalago,
Recuse.
Brunel Neville,
Yes.
Harold Perry.
Yeah.
Jared Ricky,
Yes.
and Eula Simeon.
Yes.
Yes, sir. Sorry.
Go ahead and entertain a motion to leave executive session.
I'll move.
Been moved. And second, take a roll call vote, please. It's Monty. Does he know that we came back in?
Oh,
I know you're recused from this matter, but
here he is.
there, all right.
Brian Crawford,
Yes.
Brunel Nevels.
Yes.
Tara Paree.
Here.
Jared Ricky
Yes.
and Eula Simeon.
Yes. And show that you did not request a response from Commissioner Montalego because he is recused on this matter. Okay, unanimously voted on all those who voted to leave executive session and come back in public session. Do we have any motions or discussion?
Mr. Chairman,
Yes, Commissioner Crawford.
in the matter of Michael Reichardt, Department of Public Safety and Corrections, Office of State Police, docket number 22-265-S, I make a motion to deny the appellant request for summary disposition of this case.
We have a second.
Second.
Moved and seconded. All in favor?
Aye.
Any opposed? The ayes have it. Well, just for the public's information and knowledge, what that means is simply we've denied what would be like a motion for summary judgment in a regular litigation proceeding. It does not mean that we've made any decisions on the merits or demerits of the discipline or the claim that the discipline was unreasonable. That will be determined after we have a trial. Thank you.
Yes, sir.
We'll move to item number 3 on the business items. Consideration of the appeal status in the matter of Kasha Domain, Department of Public Safety and Corrections, Office of State Police, docket number 21-250-T. Kasha Domain was ordered to appear and be present for this matter. Is she present?
I'm Keisha Domain.
Kasha Domain, all right. We previously, this matter previously came up, and we just want to know whether you are continuing your appeal or not.
Yes, sir. I'm asking for a continuance because most of my evidence is wrapped up in the federal trial this time.
A federal trial of what?
Civil trial for my case.
And when you say it's wrapped up, what do you mean? by that?
All the evidence I have is coming out right now as we're going through depositions in the case. So anything I could say to defend myself at this point, my attorneys have advised me not to say anything until the conclusion of our trial.
Till the conclusion of a civil trial.
Yes, sir.
Okay. I understand that's your advice of counsel, and so it's your request that we not proceed with this matter during the pendency of this civil litigation. Is that what you're asking us?
Yes, sir.
The commission will have to discuss that request. Has there been a motion filed to that effect?
She had a stay and then there was a motion for summary disposition filed by LSP. And it was to lift the stay and to decide the case in their favor. And the stay was lifted. So the stay has already been lifted and the motion was denied. So there's no longer a stay on her matter pending before the commission.
The previous stay was based on the pendency of a criminal investigation. An ongoing criminal
Yeah,
investigation.
it was.
So without giving any indication, because I don't have one, as to how we would rule on it, I think we would need to have a motion to stay the matter. Can that be done orally?
Yeah.
Okay, so are you making an oral motion for us to stay the matter? Okay, all right. Well, the commission will consider the request. So at this point, since this does involve the discussion of alleged misconduct, I'd entertain a motion for us to go into executive session.
I'll move.
So moved and second, take a roll call vote.
Brian Crawford,
Yes.
Monty Matalaco,
I'm going to recuse also for this matter and abstain from voting, but this is the last.
That's
Brunel Neville,
Yes.
Harold Paree.
Yeah.
Jared Ricky,
Yes.
Eula Simeon.
yes. Okay, we're gonna go into executive session, which means we weren't here before. It means everyone has to leave the room, have to take all your belongings, don't congregate outside these doors, go out towards the atrium area. But stay, because then we'll call you back in, so we'll let you know. Okay, entertain a motion to leave executive session and go into public session in the so moved in the matter of Acacia Domain, Department of Public Safety and Corrections, Office of State Police, docket number 21250-T. So the moved in second.
Second.
Brian Crawford,
Yes.
Vernell Nevels.
Yes.
Harold Perry,
Yes.
Jared Ricky,
Yes.
and Eula Simeon.
Yes. Do we have any motions? I would move to deny the request for a stay in this matter. And that the matter be set in the regular docket and proceed forward.
Second.
It's been moved and seconded. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it, which means the matter is going to be docketed. I understand we're looking at a docket that probably is not any sooner than October. But the parties are, we don't have anybody for state police. Parties are also ordered to meet with our referee immediately following our meeting today to talk about the schedules and timing. Also ordered to return telephone calls or correspondence so that we can stay in communication. There's been some effort to communicate with you and there's been no responses. So we need you to respond. We can't just show up on the day of and we've been trying to get in touch with you, okay? We make that an order of the commission as part of the condition that we are going to continue to evaluate your appeal is that you've got to cooperate and return our referees calls, okay?
And
If
if I
there's a
may,
better number that we need for you, give it to her.
Yeah, when we meet after today.
if I may, just appearance for the record, Jason Hessick on behalf of Office of Legal Affairs, Department of Public Safety. And we will, I'll share my contact info with Ms. Domain and we'll get the ball rolling with Ms. Feeney.
Thank you. Move to item number 4. It's a request by Commissioner Reichardt to speak on the subject of Louisiana State Police pay schedule.
Thank you. I won't take long on this, but in your docket, you will see that there was some information sent to us. And to quote Ronald Reagan, it's nice to trust, but we need to verify this information to make sure it's right. In conversations with Mr. Hanneman, I also understand that State Civil Service is doing some type of comprehensive pay. You can go into a little bit of detail about it. So we'll get that information as well. My purpose today is to put this in front of our eyes, to take a look at it. When you look at some of the facts of where we rank compared to other states, both with our starting pay with and without benefits and the first year with and without benefits, we are woefully low. I do appreciate Mr. Burns' comments earlier. And quite honestly, I couldn't agree more. You know, if it was a simple solution to just throw money at problems and make problems go away, I'll be frank, I wouldn't have any problems. But point is, that's just not what I'm suggesting here. What I'm saying is there are a lot of bills that need to be corrected, and I believe the current administration is doing that. If we take some of the statements made before, state police is trying day by day to make this an elite force. They're making changes day by day. They're doing, I believe the administration is doing what they need to do, and they are pushing forward. But we need to do our part as well. And our part is making sure that when you're in a competitive nature, like law enforcement is right now, probably one of the most competitive fields there is right now, because of the fact that it is very hard to get qualified individuals to agree to wear the badge and put themselves in harm's way daily. And when you look at the surrounding states, not just all the states, but their surrounding states from us, and you see the huge difference between what Texas and Arkansas and other southern states are being able to pay and offer their troopers versus what we are. I go back to my business life, which is when you have a lot of competition for very few employees, there's probably 1 or 2% of people out there that are going to do something surely for the love of it. Everybody else has a family to pay and a family to raise and bills to pay. We have got to be competitive with our pay. Again, to Mr. Burns's point, it's not one part. This is a multi-tier issue. There needs to be better public relations. And I think, the state police is working on that. We need a more stabilized academy. We need to get an academy scheduled for every August and have the funding there to do this. Not going back to the Jindal years, 6 years of no academies, because that's how the governor chose to balance his budget. Or let's have an academy when the need gets so bad things happen and makes the press. Part of fixing the ills that they need is going to take money, not just pay, but money from the legislature. But we've got to do our part up here, which is start investigating this, start understanding it, and help these guys be a part of the solution. And maybe if we're able to get them the pay they need and they can demand higher people, higher quality recruits, then maybe a lot of the reasons why we're sitting up here dealing with disciplinary actions will go away. So, like I said, I don't want to sit here and get deep into the details. I wanted y'all to get this information. Jason's going to have some more information for us next month. In between now and then, I'll make sure I get as much information as I can get, and I'll get it sent out to everybody. But it's something that I wanted to start getting that seed planted with all of y'all. And so we can help move this forward. Because I'll be honest, I thought we were doing much. I thought Louisiana State Police was further to the top than where these graphs show that we are. So with that,
I just want to join Commissioner Wilkins' comments and reiterate what I know you've already heard from this chair and from everybody else sitting on this commission. I'm extremely concerned about what maybe has gone on in the past. And my expectation and the expectation of the rest of this commission is that's not going to continue going on. And that y'all are going to take the steps that are necessary to ensure appropriate and proper discipline under the circumstances where appropriate and proper discipline is necessary. One of the reasons I took offense to the comment that was made in the last argument, because this commission is extremely concerned about making sure that when discipline is needed, it's needed and that it is put in place. My expectation has been, and that's been fulfilled as far as I currently know, that expectation is that will continue. But also that you will also have the support of this commission as regards other things, including financial support of this commission when it is appropriate. But it's to whom much is given, much is expected. So just keep that in mind.
I think the term that you used, competitors, I think that's absolutely appropriate. We talk about local law, the partners, but when you're looking at recruiting and retention, the competitors. And when you have, New Orleans, for example, that is allocated 30 officers over the next 3 years, that's really significant. So, I'm enthusiastically hopeful to recruit and retain good quality candidates. And if this is, just one part of that, one piece of this puzzle, then truly and wholeheartedly support looking into this issue.
and one thing.
Sure.
And let me, before I hear it from the peanut gallery, this is not an attempt on my part or anyone I believe sitting up here to quote, reward bad behavior. That's just not reality. The reality of it is you have a lot of dedicated, hardworking individuals at Louisiana State Police that probably take more offense than we do as a general public to the ills of the past that have happened. And my point in doing this is to help weed out those ills by being able to give y'all more money to hire better people and to attract the proper people come in and help get the people that are filling those spaces out of the way through discipline and through the actions that y'all are taking, through the policy changes y'all are taking. And you cannot starve bad behavior out of people. It just doesn't work. What needs to happen is we as a commission need to help get y'all all of the resources you need. And we need to be able to pick up the phones and call the legislators in our districts that we represent and get them on board with this. And we need to act like partners in correcting the problems that y'all have and getting y'all the resources, no matter what those resources are, to be able to demand higher standard to come in and start filling the ranks.
Okay, we'll move on then to the next item.
Mr. Chairman, if I may. Mr. Chairman, if I may, I know I wasn't on the agenda to speak, but if I may address the item that we just covered at your will, please. Real brief, I will be, because I know that time is well spent. I'm very mindful and I know how the flow go and I listen well because I've been here before when you give instructions. So thank you first for the opportunity to allow me to speak. Commissioner, thank you for bringing that up, the conversation so that we can begin to talk about the things that it is that we believe would impact and help us build a much better and stand on the terms and the flag that we carry as being an elite law enforcement agency. Also, Commissioner, my first time addressing the board with you here this morning, so welcome and congratulations to your appointment. I'll be real quick. When Colonel Davis started selecting his executive staff, one of the things that he asked myself and several of the other lieutenant colonels and commanders was, do you have your running shoes? And had no clue what that meant when he asked, but while I'm now appointed in this position, I can clearly understand what he meant. Since day one, we have been running nonstop to ensure you and the public that we're making this agency a premier law enforcement agency. And to your point, Mr. Chairman, to whom much is given, we understand that much is required, not just in law enforcement with state police, with any public servant that comes in this world today. It takes a special person to come in and want to serve. We only talk about serving many times, but we hardly ever add the other piece with law enforcement, and that's the protection piece. We ask a lot of our troopers to serve and to protect. And in my study and in my research here lately, I've learned that a lot of folks, not just Louisiana State Police, Mr. Burns, but a lot of folks leave jobs because they don't feel appreciated. It's the number one reason why most folks are leaving. And to your point, sir, we hear you loud and clear about the recruiting and retention piece. And from my heart to yours, I want you to know that we're working tirelessly every day, tirelessly to recruit the best and most well-deserving people that are educated, that understand the constitutional policing, the ethical policing piece that it requires to be a law enforcement agent today. But it's not just isolated to Louisiana State Police. Chiefs of police across this country have done a survey and showing now that there are over 50% of law enforcement agencies today that are operating with less staffing than they did 3 to 4 years ago. LAPD is down 300, Philadelphia down 600. Just down the road, New Orleans is down 300. So it's not just Louisiana State Police. My colleague came to you last commission meeting, Lieutenant Colonel Jody Hasselbeck, and he gave a clear picture as to why folks are leaving state police. There are several categories that we can look at. One, if you just take history and go back and look into our career as state police, you would see that in 1995, Commissioner Montilago, we had several large classes that came in state police. And when you add the numbers up, if you take 1995 and add it up to now, they've been eligible, have become eligible to retire. So do you hold that against a person for leaving and wanting to retire and move on? And Colonel Hasselbeck gave a very good optics of how that brought us to today. While we're not foolish and aware or not aware that some folks are also leaving for various other reasons, Mr. Chairman, to the point in the subject that was just raised, we hear you and we're doing everything we can from our vision, from Colonel Davis's vision and the rest of our commanders to make sure that you, the commission, don't keep getting these disciplinary actions that we should not be getting. A lot of it tends to lean to lack of accountability and transparency. But we hope in the last 2 years, you have seen that we have held our folks' feet to the fire, that they will be held accountable and they will be transparent in everything that we do because the public deserves that. That's why we're here. So, Mr. Commissioner, again, thank you. I know that you asked me to be brief, and hopefully that was brief enough. And I will close my mouth and follow your instructions with that, sir.
It was close. It was close.
Thank you.
You know, closey's only counting horseshoes. So. And that too. All right. Any other discussion on item 4? Thank you, sir. We'll move on to item 5. And I was the one that requested this item be put on the agenda. However, unless one of the other commissioners has some discussion on that, I'm not prepared to discuss that issue right now, in part because we're getting our responses too late. When we need statistical data, when you need information, we don't need it the day before the commission meets. We're all busy, and I know y'all are busy people, but we're busy and we gotta have information so we can have time to digest it and evaluate it. So unless there's an opposition, then I'll just request that this matter be moved to the next meeting.
I just wanted to make sure you got it, even if it was yesterday, that we weren't still waiting.
Well, it was yesterday, but
Okay.
we got some.
Well, we got it, so at least we can talk
Well-
about it next month.
Well, let me evaluate whether we got what I needed, but
Okay. Okay.
because I haven't had time to do that yet.
Mr. Chairman, you should have, and I'll apologize first on behalf of the department. We understand you asked for these demographics. Last meeting we had, I was under the impression it was mentioned that it was put in your binder. I don't know if that was all of the information. However, myself and executive director, as well as our HR team and our executive assistants have met since then to talk about when we have these commission meetings, that we are going to make sure that whatever's requested, we're not waiting till the 11th hour for you and the team to get it. It is not our hope that you get the stuff at the last minute, because I do know it requires time for you to evaluate it. So on record, we apologize for that, and we hope that you'll see in the future that you won't be waiting this long to get it.
And we'll be Mr. Hanneman will be in communication with y'all as we evaluate the evidence and information we have, whether there's a need for more.
Yes,
Okay.
sir.
Any opposition to moving it to the next? Okay. Hearing none, we'll just move it to the next. The next item is consideration of a request by Commissioner Reichardt to address the question of whether the commission should provide an exception to the approved job duties of WAEs that would permit performing public safety tasks throughout the state, not solely during the Mardi Gras season.
Thank you, sir. You all may remember last month, you were kind enough to help with allowing the WAEs to work during the Mardi Gras season. Since then, I've gotten a lot of positive feedback from people in my district and the surrounding districts, and made it a point to have a conversation with the colonel about his thoughts and feedback on how that worked. And it sparked the discussion that, as we just spoke about, being so short-staffed right now. And I was actually made aware that something I didn't know, that there's actually WAE positions that they can't fill, not just full-time positions that can't be filled because of personnel shortage. So it started the conversation about, well, maybe we should allow these WAEs to be used at other times. There's other parts of the state. I hate to be so, regionalized with my thoughts towards Mardi Gras. There are other parts of the
Shreveport.
and Shreveport, yeah, that's right. That's cute. Sorry, Brian, that was a shot. But there's other parts of the state that are in similar situations. Plus, as we're coming up on hurricane season and, natural disasters and events. So the thought is to allow this for some period of time to be opened up, to be used as the colonel would see fit. If it was some extended amount of time, obviously they would have to notify our executive director so we know what's going on. But that would be more of a notification, not an ask for permission, because we can't slow these kind of things down. I mean, if we talk about hypothets, something terrible, an airliner crash on a neighborhood or something like that, these kind of things that I've seen in my life back in Metairie, as you remember back when we were kids, those kind of things. There could be a need.
Yeah.
So, but anyway, with that,
Again, thank you, Commissioner, and Mr. Chairman. Listen, we This WAE piece has been a topic of discussion here at our this boards here. We have about 71 total WAEs that you will see in your packet. And oftentimes it should be noted that our WAEs, for those who may not know, are fully commissioned, retired state police troopers. What that means is that they have the ability, they have the resources, they have the training from years of being within our agency to still function outside of retirement in the roles that they're in, coming in as WAEs. The initial point of having our WAEs was as an added bonus and support to the work that we do. And in those places where we can feel or can't feel a trooper, the WAEs with their experience will come in and be helpful for us. With this discussion, and thank you again for what you allowed last meeting, board. We are looking to find a better way to make sure that across the board we can utilize our WAEs. And listen, we have a group of folks that do an incredible job. I can tell you from I did a walk this morning to go and meet with a couple of them to just be specific about their job and make sure that what it is that they're doing is what we've talked about. And if we had lost or had not had this in particular, one in concealed handguns, one of our WEs that works in concealed handguns, I asked him to walk me through his workday. And on an average, he's getting tons of requests for concealed handgun carry permits. We have a supervisor in that position, in that section, no troopers. He's the main point of contact that touches most of our requests and denials and has to write denial letters. I'm just giving you that as an example. That's just one of reasons why that position and that WAE request is so important to us. So again, Commissioner, thank you for seeing that and at least addressing or trying to address a way for us to move forward with the authorization of using them in times of crises. But like last month, unusual situations like Mardi Gras, we've requested for one of the balls, there was a request for 140 troopers to work. We filled about 115 of those positions. We had 2 WAEs that worked that position, still didn't meet with the request asked for. Now take a look at that piece, 140 something requested. That's separate and apart from what we've obligated to the city of New Orleans, 125 troopers. So we have to look across the state. And there were personnel from our department from across the state coming in as far up as the Crawford as Monroe to come and work and help and be a supplement and support for a public safety need. So to your point, we support whatever advice, direction you may have, but we look to help hopefully make this WAE process much better moving forward.
And let me just say, and I think Commissioner Reichardt would agree with me. Obviously, the WAE program, at least in my view, is a stopgap measure. We look forward to the day when there are enough commissioned troopers who are actual full-time employees to fill all of these needs. And any support that I would give to the proposition would be with the understanding that it's temporary. Until we fix the problem. You got to have a bandage until you stop bleeding. And you got to, but once the bleeding stops and once we get the personnel in place, I would be much less inclined to support expansion of WAEs. But and I understand that's y'all's position as well. I just want to make sure that everybody viewing what we're talking about today understands that we're not talking about a permanent solution. We're talking about a temporary solution to the current problem.
Received, sir.
Anybody else? We'll move on to the next item.
Thank you.
The director report.
Do we need a motion?
Well, yeah, I think we'd have to put it on the next agenda because it wasn't the way it's listed on the agenda. So we'll have a motion on an agenda item for the next meeting to possibly expand the use of WAEs. I don't think procedurally right now we would do that properly.
I'll email you my thoughts.
On the agenda.
Thank you.
Thank you.
Technically, obviously, we could do it with a unit with a 100%. We could add something to the agenda as we've done in the past, but considering the significant nature of what we're talking about, I would suggest we do it as a regular agenda.
I'll put my motion together.
Okay, with that, we'll move to the director's report.
Yes, Commissioners, I think behind tab number 7, will you find the budget expenditures for the agency? We are on track. Have any questions?
It's a hearing that.
Hearing that, the other item I wanted to mention is that the legislative review for the budget for the next fiscal year is tentatively set for House Appropriations on March 28th and Senate Finance on March 29th. Everyone's welcome to attend. Eric and I will be there, ready to answer questions of members of the legislature that they might have about our budget request. I don't anticipate any controversial items. Our request was adopted into the executive budget. And so it looks like we are good footing going forward. The other item I just wanted to remind you of is the personal financial disclosure statements covering calendar year 2022. Those are due to the Board of Ethics by May 15th, 2023. The tier 2.1 disclosure statements, they're in the front of your binders. We'll also email you the link. It's disclosure form 417. And you can file those online with the Board of Ethics. And then the last item is just to mention that the next meeting is set for April 13th at 10 a.m.
Did we receive any requests to address the commission on items not on the agenda?
We did not.
Having received no requests, the meeting will be adjourned unless there's opposition. We adjourn. No opposition will be at adjournment until the next meeting.